You just received a letter from the United States Attorney's Office, and it calls you a target. If you're reading this, you're probably panicking right now. That's normal. But what you do in the next 48 hours matters more than anything that happens after. Most people who get a target letter make the same mistake. They talk, they call people, they try to explain, and that's exactly what the government is counting on. I'm Richard Suzuki. I used to be the person who sent those target letters. As a former federal prosecutor in Arizona, I presented to grand juries authorized target letters and watched what people did next. Today, I'm telling you exactly what a grand jury is, what the letter means, and the 3 things you must do. And the 1 thing you absolutely cannot do the moment you receive one. Let's start at the beginning. A grand jury is a group of citizens, typically between 16 to 23 people, and a federal grand jury, who are convened to decide whether there is enough evidence to formally charge someone with a federal crime. Their job is not to determine guilt or innocence. Their job is to determine probable cause. Is there sufficient evidence to believe a crime was committed and that the person committed it? The standard is much lower than beyond a reasonable doubt, the standard at trial. Grand juries deal in probable cause, which is a very low bar. Here's a critical thing you need to know about grand jury proceedings. They are secret. The proceedings happen in a closed room. No judge presides over the questioning. Defense attorneys are not allowed in the room, not even your own attorney. The prosecutor presents evidence and calls witnesses. The grand jury asks questions. Then they vote. If at least 12 jurors vote that probable cause exists, they return what's called a true bill, an indictment. If they vote against, they return a no bill, and no charges are filed. In federal court, the indictment rate historically hovers around 99.7%. When federal prosecutors bring a case to the grand jury, they almost always get the indictment. That number is not an accident. Federal prosecutors do not present cases they're not confident in. By the time a case reaches the grand jury stage, the investigation is largely complete. The evidence has been assembled and the outcome is nearly predetermined. The grand jury process, in practice, is largely a formality, though there are exceptions. When it comes to a federal grand jury investigation, your status matters enormously. There are 3 designations. A witness is someone who has information that's relevant to the investigation, but is not themselves suspected of criminal conduct. Witnesses can be subpoenaed to testify before the grand jury. They have rights, but they're not the focus of the investigation. A subject is someone whose conduct is within the scope of the grand jury's investigation. They're not directly in the crosshairs, but you're in the picture. Subject status is a warning sign. A target is someone whom the government has substantial evidence linking them to a crime and who is the main focus of the investigation. If you're a target, the government believes you have committed a federal offense and is building the case to charge you. A target letter is the government's formal notification of this status. Here's the important nuance. These designations can change. A witness can become a subject. A subject can become a target, and the targets who cooperates effectively can sometimes negotiate their way to a different outcome before indictment. The fluid nature of these designations is part of why responding to a target letter without an experienced legal counsel is so dangerous. If you receive a target letter, the government is telling you 2 things simultaneously. 1, we believe you committed a federal crime. 2, we haven't charged you yet. Target letters sometimes invite the target to testify before the grand jury. This is a trap. I don't use that word lightly. Testifying before a grand jury as a target is almost never in a target's interest. Here's why. Anything you say to the grand jury can be used against you. If you say something that contradicts other evidence, you potentially added a false statement charge to your exposure. You are not protected by having your attorney in the room. They're waiting outside. You have Fifth Amendment rights that allow you to refuse to answer questions that might incriminate you, but invoking those rights has its own strategic implications. Experienced federal defense attorneys almost universally advise targets not to testify. That decision has to be made carefully, with full knowledge of what the government has, what they're trying to accomplish, and what the potential benefits and risk are. The moment you receive a target letter, not the next day, not after you talk to your family, you call a federal criminal defense attorney. You call me. That is the single most important action you can take, because the window between the letter and an indictment is often the last window you have to meaningfully affect the outcome. As a former ASUA, I can tell you what's happening on the other side of that closed door. The prosecutor has a presentation prepared. They call witnesses, often agents who've been working the case for months. They introduce evidence, electronic records, financial records, surveillance materials. They walk the grand jurors through the case narrative. Grand jurors ask questions, but most defer heavily to the prosecutor's framing of the evidence. The grand jurors are not adversarial. They have no reason to be skeptical of what the prosecutor presents because they're only hearing one side. There is no defense. There is no cross-examination. There is no competing narrative. It is, by design, a one-sided presentation. That is why 99.7% indictment rate exists. It's not that federal prosecutors are always airtight cases, it's the process itself is structured to favor the government. Federal indictments are often sealed at first, meaning they're filed with the court but not made public. This is done to prevent targets from fleeing or destroying evidence before law enforcement can execute arrest. A sealed indictment can sit for days, weeks, or longer while agents coordinate the arrest. When the seal is lifted and the arrest happens, it can be coordinated across multiple jurisdictions simultaneously, especially in conspiracy cases with multiple defendants. This is standard federal practice and reflects how thoroughly the government has planned the case before anyone knew charges were coming. If you're arrested on a sealed federal indictment, you have no warning. Your first call after that arrest needs to be to a federal defense attorney. Even in this heavily government-favored process, you have rights. You have the Fifth Amendment right against self-incrimination. If you are subpoenaed to testify and your testimony could incriminate you, you can invoke the Fifth Amendment on the question-by-question basis. You have the right to leave the grand jury room and consult with your attorney after each question, even though your attorney can't be present during the testimony itself. This is an important and underused right. If a question is asked and you're uncertain whether answering it could incriminate you, you can say, I'd like to step out and consult with my attorney. If the government offers you immunity in exchange for testimony, there are two kinds of immunity: transactional immunity and use immunity. The difference matters significantly for your exposure. These decisions should never be made without experienced counsel. Why federal grand jury exposure requires federal defense experience. I was also a former state prosecutor with the Maricopa County Attorney's Office prior to working as an assistant U.S. attorney. I know that state criminal defense experience, while valuable, is not the same as federal criminal defense experience. The rules are different. The procedures are different. The judges are different. The prosecutors are different. Federal prosecutors are typically career attorneys who specialize in federal law. They're not rotating through an office handling hundreds of misdemeanors or state felony cases. They work complex, resource-intensive cases. Defending against federal criminal charges requires someone who understands the federal system from the inside, how federal prosecutors think, how they build cases, what leverage they hold, and what they are vulnerable. The inside knowledge is not something you develop reading textbooks. It comes from having been in that room. From the grand jury and federal indictment, let's shift to something a lot of people face here in Arizona: a violent crime charge, specifically assault with a deadly weapon. In the next video, I'm going to explain what actually qualifies as a deadly weapon under Arizona law, and the answer is going to surprise you. Plus, defenses that work, how prosecution builds these cases, and what winning actually means when you're facing this kind of charge. That's next.